Hey there, everybody. This is David Corkett at the Grig Group. Thank you all for joining us today. We are in for a treat in regards to learning everything you need to know about ERISA. We got some amazing lawyers on the phone with us today to kind of go over all the specifics, and they'll be able to share lots of details and answer questions at the end.
Well, fantastic. Yeah, thank you, David, and thank you everyone for if you're west, thank you for getting up early, and if you're you know getting closer to lunch and your stomach is growling, thank you for hanging in here with us. We are going to go over what is can be a boring topic at times, but probably one of the most critical pieces if you have any level of benefit plan, be it a one-person SEP plan because you're a sole practitioner, to a 100, 200 person company working with welfare, with a health plan and dental and vision. This is an area, despite some of the media reports that we're going to back off of all of the different the laws and make presidential changes and not enforce as many things. Things like the DOL, the EEOC are not only did they staff up in the last year or so, now they are really getting to a point of being able to execute and send their people out to do audits. And so the fines around ERISA, which is really the governing law around all really welfare benefit plans. We're seeing case law in the 6 and 7 figures for things that most companies either didn't know they were doing or should have been doing, and maybe look to their brokers to do, or their administrative companies or their third-party administrators to do. And as we'll talk about in the presentation, the plan sponsor or the employer is not off the hook because they have third parties helping. The plan sponsor is always responsible and always liable for all of the notifications and documents and those things that go out. So I'm pleased to have with me from our Wisconsin office, Andrew Nielsen, who's our Director of Compliance, all around good guy, practiced for a dozen plus years, has been a prosecutor, and really writes a ton of our content, our legal documents, etc., that our 60 or so attorneys use. And then next to me here in Minneapolis is Janelle Stanton, who's our Director of Communications, who gets out all of the information from the standpoint of our blogs and predetermined information to try to keep our clients proactively out of trouble, but also does a wonderful job in presenting information to our clients weekly, monthly, and quarterly when we go to trade shows, etc. So with that, I will hand it off to better people than me. And if you have any questions, I should just say from a housekeeping standpoint, you can click on the questions button in the GoToWebinar, and we'll observe those as we go along. And to the extent that they hit the areas that we're in at the time, we'll certainly answer them. And then we'll always have time at the end to answer any questions. So take it away.
I'm sorry, Mark, before you get going, I think you need to share your screen because all I got is the fun white page.
Okay.
So that we can see the deck.
Absolutely. Thank you for... How's that?
That's beautiful.
All right.
Everything I ever wanted.
Perfect.
All right. Once again, I'm Andrew Nielsen. I'm in the Wisconsin office. I think it's a beautiful 30 degrees here today, but at least the sun is shining. ERISA is, as Mark said, probably not the most exciting topic of law. I've undoubtedly practiced in many more exciting areas, including putting people in jail and prison and people biting other people's fingers off. ERISA does not rise to that level of excitement, unfortunately. That does not mean it is not important. And I've done everything I can. I think I've given a lot of presentations on ERISA in the last couple of years, and I've done everything I could to try to make it exciting. In fact, I even went so far as Googling multiple times between when I started giving ERISA presentations and even again this morning to try to find jokes about ERISA to try to make it more exciting or enticing. The sad news is that there are no ERISA jokes, which has now, to me, become a joke in and of itself. But if you guys find one, hit me up. I'm always game for an ERISA joke. But we're going to start in the basement here, I guess, just a broad overview in terms of a foundation, and then we're going to go stream up into specifics. But what is ERISA? ERISA stands for the Employee Retirement Income Security Act. It's administered by the Department of Labor. It also has a little bit of to do with the IRS in terms of some stuff we'll touch later. And there's a specific portion of the DOL that plays around with all things ERISA called the Employee Benefits Security Administration. And basically they are the sub-agency within the DOL that is on the hook for making sure that everybody toes the line when it comes to ERISA. With that, I'm going to hand it over to Janelle. And basically what we're going to do today is we're just going to trade off every other slide so you don't get sick of one of us or the other.
Awesome. Thanks, Andy. Yeah. So a little bit more on the background about ERISA. So the problems come up with ERISA and why so many employers are out of compliance, like Mark kind of touched on when we first started talking, is there's an overall lack of awareness in the marketplace. So we talk to a lot of our clients who don't know what ERISA is. They're not aware that this is the law, that it is something that they have to comply with. And part of that has to do with the fact that there's an assumption that insurance carrier documents are SPDs. And unfortunately, those certificates of coverage or certificates of insurance, those documents that you get from your insurance carrier, those are not considered to be summary plan descriptions. They go along with a summary plan description, but they are not SPDs in and of themselves. So insurance companies, when they write their certificates and their contracts, they're trying to be compliant with insurance laws. And obviously, that's what they do. So they are in compliance with those insurance laws, but they don't necessarily have to comply with those ERISA regulations that apply to employers. That is the job of an employer, to make sure that your employee benefit plans are compliant with ERISA and that you're making sure to get those documents out. There's also a lot of confusion. The complexity of ERISA is not to be underestimated. This is something that stumps seasoned attorneys that practice mostly in ERISA. The statute itself takes up many, many chapters in the book, and they cross-reference each other, and it's very complicated. So sometimes I think that it's really easy for people to say, forget it. I don't care, because it is complex. How likely am I really to get caught? And unfortunately, this compliance is not an option. It's the law. It sounds trite, but essentially we're going to talk more about this, but this is an area that has stepped up enforcement recently and has come more to top of mind for not only employers, but also attorneys that counsel employers as well. And just from a statistics standpoint here, there's some statistics out there, and I don't know how accurate these are, but I thought they were interesting, so I figured I'd throw it out there. But there's a statistic somewhere that I saw that said 90 to 95% of employers have at least one violation of ERISA regulations. So one violation on its own can be very costly, and compliance with this law is very, very important.
All right, and here's just a brief overview of the topics we're going to dive into a little deeper in order. We're going to start out with ERISA. We're going to get into the weeds with ERISA a little bit. what's covered, what's not covered, safe harbors, exemptions, what you need to do to comply with it, some of the basic rules. We're going to talk about SPDs. I think we talked a little bit about SBCs later. SMMs, SARs, any other acronym you guys want to throw out there, we can talk about them too. And then I think we're going to finish up on 5500 reporting, and then a nice little calendar overview about ERISA and compliance and timing requirements.
All right, so with that, I'm going to go through a definition and some more background here. So ERISA stands for the Employee Retirement Income Security Act. It's federal law. It was enacted in 1974. And it actually, if any of you are car enthusiasts, it came out of Studebaker Corporation in South Bend, Indiana. And unfortunately, Studebaker really didn't what over on their employees. So December 23rd, 2 days before Christmas, Studebaker announced that it was going to be closing its plant. There were 5,000 workers that were dismissed. And what happened was their pension plan was terminated. That covered almost 11,000 employees. It was underfunded. There was not enough funds to cover all the vested benefits there. So you had some employees that had 40 plus years of service for Studebaker that missed out on receiving a full pension, which was then age 60, by just a few months. So you had 3,000 employees left without jobs and without pensions 2 days before Christmas. So real live Grinches there. But that spurred the creation of the Employee Retirement Income Security Act, and it's part of the labor code section, and it governs the structure of employee benefit plans. So it has specific requirements regarding disclosures to covered individuals, various reporting requirements that need to be made to government entities. There's also some strict fiduciary rules, and we'll touch on those a little bit more later on. There's also an enforcement mechanism. So Andy is going to get into sort of that enforcement mechanism here.
Yeah, and basically just going to highlight why it's important to have everything, all your ducks in a row and everything important from this very important Christmas present that we got. Rising out of Studebaker's Christmas present to its employees, or lack thereof. So these are some lists of some of the fines that the government has handed out lately for non-compliance with the ERISA rules. You can see them right there: $86,500 for failure to complete an accurate Form 5500, $241K for failure to provide a summary plan description to our participants, and just under $11,000 for the same thing. And where these fines come from is there's actually a number that they use to figure it out. They don't just guess to figure out how much somebody should be fined. So for summary plan descriptions, the employer has to provide the SPD upon request to the participant. If it's not done within 30 days, there's a penalty of $110 a day per participant or beneficiary, which can add up pretty quickly. In addition to that, we have you can have a lawsuit brought by a participant in the plan. You got attorney's fees on that. You've got all sorts of additional costs in addition to the penalties that the DOL will hand down. And these things not only will come from lawsuits, they'll come from complaints filed by employees to the Department of Labor, or they can come out of a Department of Labor audit, which are on the rise for health plans, especially due to the Affordable Care Act. We'll see what happens with that down the road. But when the DOL starts their audit, especially if it starts with Affordable Care Act stuff, first thing they're going to ask for are your plan documents and your summary plan description. If you don't have a summary plan description to give them, it's an inauspicious start to any sort of audit. And it's going to likely lead to that auditor looking under every single rock they can find and increase scrutiny to see, what else you guys might not be complying with if they come in and say, hey, where's your SPD, and you don't have one.
Yeah, another tool that the Department of Labor has put out there is this Department of Labor Consumer Assistance webpage. And the effect of this is anybody, any member of the public can very easily go to this website, which they also provide in Spanish, and allow people to submit questions and complaints about their plan. So if as a plan participant or beneficiary, you believe that your employer is in some way violating ERISA, you have the right to then go to this website and file your complaint. It makes it very, very easy. And if you have an employee that goes in onto this website and files a complaint, it's going to trigger an audit. And in 2014, just as an example, the Department of Labor put out their audit summary, and they said there were 687 new investigations that were opened as a result of participant complaints. So that's a huge amount of complaints that people are raising through this website. And what that means is, like Andy was just saying, it makes it a lot easier for an audit to be triggered. So we're going to touch on later how the ACA, the passage of Obamacare, impacted this new regulatory landscape. But if you have an employee that is easily able to go on, fill out an online form and make a complaint, it's going to trigger that audit. And believe me, we have, we've talked to clients that have had the Department of Labor show up to do audits on various things. You do not want the Department of Labor knocking on your door. Like Andy said, it can lead to not only an audit of your, ERISA compliance, but other types of compliance, FLSA, those types of things. So definitely is something that you want to be careful of. That Employee Benefit Security Administration, they're the ones that do these investigations to make sure that employers are compliant with these laws.
And then this is just a simple visual overview of the ERISA statutes that are important, rather than list them all out and risk putting you all to sleep. These are the important parts. So if you ever see something about Title I of ERISA or Part 1 or Part 5 or Part 7, this is what the stuff, that literature you might be reading refers to. A lot of times practitioners just refer to, Part 1, Part 4, Part 7, just as a sort of shorthand, without realizing, or maybe with realizing, that normal people don't understand what the heck any of that means. A lot of the stuff that we're talking about here is going to, come in Part 1, reporting and disclosure. Part 4, probably not so much going to affect you guys unless you have a trust that's funding a self-insured health and welfare plan. It does touch a lot more with the retirement plans, where there's funds being held for pensions and whatnot before they're transmitted to a third party for administration. Part 5 is where all the bad stuff is. This is where the penalties are. 6, COBRA, pretty straightforward. Everyone should know what COBRA is. And Part 7 is a lot of the newer, quote unquote stuff. HIPAA, the right to special election or special enrollment rights, FMLA rights, newborns and mothers' health protection, women health and cancer rights, the mental health rights. All that stuff is covered under the I guess I call the newer section, Part 7.
So getting more into the meat of what is actually required of employers. So I'm going to define for you a welfare benefit plan. So ERISA obviously covers welfare benefit plans, and these are a plan, fund, or program that's established or maintained by an employer. So obviously established to provide welfare benefits. So these would be things where you're getting a new job and they're going over all the different types of benefits that you're entitled to, and these are established and maintained by that employer. So they're making contributions likely, they are allowing you to pay for that through a payroll deduction and it's meant to be a benefit to you as an employee. So this is not things like if you are, watching The Price is Right and you see a Colonial Penn life insurance commercial, and you go out and you buy that life insurance completely on your own, separate from employment. That's obviously not governed by ERISA, but there are most other types of benefits that you get through work then are considered to be a welfare benefit plan. There is an exception for voluntary types of insurance where, if the employer isn't making any contributions, it's a completely voluntary participation where the sole function of the employer is basically just to bring in that insurance representative to, publicize their insurance offering, and the employer doesn't get any commission off it. There are situations where even if let's say you have somebody from Aflac come in and give a presentation to your workforce, if it's not something where you're making contributions, it's voluntary, and the employer's only function is to really just bring them in to do this presentation to the employees, then that also is considered voluntary insurance that's not covered by ERISA, where an SPD likely wouldn't need to be issued. But these plans are really easily created, and so there's most benefits are going to fall under this definition of welfare benefit plan.
And here we're going to talk about the types of plans that are subject to ERISA governance. Health plans, group health plans are pretty obvious. Those are probably the major one that most people would think of, and the most common one out there. Followed closely probably by dental and vision plans. After that, we have FSAs, HRAs, all of which make sense because the money for those come out pre-tax most of the time through employer agreements. ADD plans, if there's an accidental death and dismemberment plan, I always like saying dismemberment because that's such a fun word that we don't get to say much. But those plans, if there's employer sponsored and they come out pre-tax, those could be ERISA governed group life insurance. That happens a lot. STD and LTD plans. Severance insurance, and I like to touch on this one. A lot of people use the word severance and separation kind of interchangeably. There is a distinct difference if you have a severance plan versus a separation plan, and a lot of people call it a severance agreement. If your company has a plan where if you worked X number of years and you're let go for X, Y, or Z reason, you get 2 weeks for every year that you were there, whatever the formula is, that is actually an ERISA governed plan that needs to have all the rules followed, as opposed to, say, a separation agreement where you let somebody go and there is no set formula for how much that person is going to get in exchange for signing a release of claims against you. That is quite separate and different than a severance plan. That's something that I see mistaken pretty commonly. And then finally, we have wellness plans and EAPs, and pretty much anything that is a voluntary benefit that is not offered pre-tax would be excluded. Any voluntary offered as pre-tax, anything that comes out before you pay, before the taxes come out, is going to be covered by ERISA. Anything that comes out after the taxes are deducted is going to be not covered by ERISA for the most part.
So these rules pertaining to ERISA and the requirements here, they apply to private sector employers. So corporations, partnerships, sole proprietorships, no matter what type of business entity is formed there, those employers are going to be subject to and have to comply with the ERISA requirements. Nonprofit organizations, so 501c3s, those are also have to comply with the ERISA requirements, which is, I think, a commonly misunderstood fact there. But yeah, nonprofits are also required to comply with ERISA, unless that nonprofit is exempt under a specific statute, which is 501A. So I'm not going to go through these 9 factors, but essentially there's this 9-factor test that the court and the Department of Labor, if they've come in to do an audit of your nonprofit, they use this test to decide whether that governmental plan exception applies. So there are some exceptions there. If you are a 501A governmental entity type of nonprofit, it is possible that you could be exempt. The test is obviously 9 factors and kind of complicated. So again, I won't bore you with details there, but just wanted to point that out as an exception on that nonprofit rule.
Other exemptions we got church plans are probably the most common ones that you guys have run across out there in the wild. Church plans are exempt from ERISA, as are most government plans, be they municipal, state, federal, county government plans. Those are going to be exempt from ERISA as well. And those additional programs like work comp, so if you have to have work comp coverage, that's going to be exempt from ERISA. If you have to have unemployment insurance, which I think every state does, as far as I know, require you to pay in unemployment on your employees, that's going to be exempt from ERISA. Disability insurance, if it's required to be maintained by state law. And plans maintained outside the U.S. for non-aliens, that's fun phrasing again. Basically, that means if you have employees in a different country, Canada, Mexico, United Kingdom, anywhere else in the world, if you have plans specifically for those employees that do not live and work in the U.S., those are not going to be covered either.
So going over the key ERISA requirements here. So the big one is that a plan document has to exist for each plan. So employers are required to give plan participants in writing, the facts that they need to know about their plans and their retirement and health benefit plans. The insurance contracts, and Andy and I, fortunately, given our roles here, we get to look at these insurance contracts, and they are a bear. I just worked on an SPD last week, and the contract was 438 pages long. So these plan documents are out there to make sure employees actually understand their benefits, and that's one of the key requirements here. There's also really pretty strict fiduciary standards that have to be adhered to. So fiduciary is just a fancy legal term to mean you have to, take care to act responsibly. So these are rules that require any people or other entities that have either control or authority over plan assets to make sure that they run the plan only in the interests of those participants. So they can't, make investments with your 401k fund into things that their family, their company that their family member owns. That is not necessarily going to be in the interests of a participant with regards to their retirement account. They also have to avoid conflicts of interest. Again, if I'm a plan fiduciary and my job is to invest in this 401k on behalf of a company, and I'm choosing the investments based on, who my family, companies where my family work, that's obviously a conflict of interest and is going to run counter to those fiduciary rules under ERISA. There's also a fidelity bond requirement. So any person who handles plan funds is required to have this fidelity bond. So what that is, it's a type of insurance that protects the plan against losses that are caused by fraud or dishonesty. So if there's any type of forgery or fund misappropriation, if a plan trustee is siphoning funds into their own pocket, that type of misappropriation is meant to be covered by these ERISA fidelity bonds. Again, summary plan descriptions, SPDs, and that's the bulk of what a lot of employers are having to comply with. Those have to be furnished automatically to plan participants and beneficiaries, and we're going to touch on that more later, but this is meant to be, you know, that quick synopsis where employees don't have to read 438 pages of awful legalese insurance contract material. It's a nice, neat package to let employees know what their benefits are. And then there's also requirements for SMM. So the summary of material modification, if there is an amendment made to a plan, there's rules about when an employer has to distribute a SMM to those participants.
I was on mute, sorry. SMMs, in my opinion, don't come up that often. I mean, they do, but if you're hiring employees, at least on an annual basis, you might as well be just updating your SPD instead of doing an SMM. That's more of a personal preference, I guess, on my end, but you're going to have to redo your SPD anyways if you hire new employees, so doing an SMM, or including with the timing requirements, is probably, you know, SMMs are probably just somewhat of a waste. But you can do them if you want to, especially if you're not going to be hiring people. Other requirements under ERISA, we've got copies of plan documents. We talked about the penalties for that earlier if you don't give them in time within the deadlines. Form 5500s, which we're going to be talking about more later, need to be filed annually for plans that are required to file them for. There are exemptions. Again, we'll dig into that a little bit. And then summary annual reports, for those of you that have to file a 5500, have to be furnished for every plan that files a 5500. And those are, again, pretty boilerplate stuff, but stuff that people usually forget or don't know that they have to provide.
Yeah, that's exactly true. A lot of employers don't consider these requirements of having the written plan. Again, they assume that what they are getting from the insurance company is enough. And I've even seen in some certificates of coverage, insurers calling something an SPD, calling it a summary plan description, but it doesn't meet their actual requirements of what the employer is required to provide. So just getting into a little bit about the plan document here. So ERISA benefits, retirement and health and welfare benefits have to be provided through a written document. So once an employer decides that they're going to provide benefits, they're going to be subject to the ERISA and then need to provide this detailed plan, written plan document. And so employers are free to design their plan of benefits. ERISA isn't meant to be out there requiring that employers provide benefits to employees. This is obviously something that employers are still free to choose to provide. Most employers do provide it to attract good candidates, but essentially ERISA is not actually requiring that you provide it. They also don't have anything in their rules or regulations that require a plan provide a minimum level of benefits. So that's more akin to the ACA. ERISA doesn't get into that, but you know, if you have an ERISA benefit, you should then have a plan. And you know, ERISA plans obviously can exist without the documents, but you're going to be out of compliance. So, you know, this happens all the time where it's not that you, it's not that your plan doesn't exist if you don't have the document. Lots of employers have employee welfare plans and are not in compliance with ERISA. So the document type, that's obviously going to be influenced by the nature of the plan benefits. So if you are an insured, if you're fully insured, your insurance plan document is going to look a lot different than if you're self-insured. So the document type is obviously going to be influenced by the nature of the benefits that the employer chooses to offer, but this plan document is very, very important.
And then we get to talk about wrap documents. Wrap documents is kind of a source of confusion and it was for me when I first started looking at them, because there's no definition of what wrap means. People use it to mean different things. And I basically break it down like this. You have a wrap document, which basically would be a piece of paper, I guess is oversimplifying it, but a document that you would attach to the plan document that contains the missing information from the insurance document, such as who is the plan administrator, how is it administrated, is it third-party administrated, is it administrated by the employer, what's the plan number, which would be your 5500 number if you have one, when is the plan year, is it calendar year, does it start March 1st, what's the name of the plan when it was adopted by the company, and stuff like that. And you can get super complicated by this. And Janelle, I don't think I'm stepping on any of your slides by saying that that's one wrap document. Oh no, I'm actually stepping on my own slides, 2 down. So I'll save that for later.
All right. Yeah.
Yeah, this is we'll call this a simple wrap.
Yeah, simple, not so simple, maybe. So continuing on these basic rules here. So again, the type of documents and, that you have to provide, the number of documents is also going to depend on how many plans you have. So, the document requirements apply to each plan. So like I said, last week I was working on an SPD project for a client. I had to do a medical plan, a vision plan, dental. I had an accidental death and dismemberment insurance policy. I had one where I had to do a health savings account. So the number of plans is really only limited to the employer's imagination about the type of benefits that they want to be providing. So there's no hard and fast rule for determining how many plans you need, because again, that's totally contingent on what the employer is wanting to offer. So one caveat, pension and 401k plans, those do have to be maintained separately. So, I have seen some where there's health and dental put into one because the insurance company is offering both. So if you're not addressing the number of issues, then obviously this can create some confusion about how many plan documents are you going to need. But again, that really is contingent on each plan that you are offering and how that plan is set up. So there's no hard and fast rules here. And it, again, is just dependent on what you are offering out to your employees.
And then we're going to talk about what I wanted to talk about 2 slides ago, bundling benefits in one or more ERISA plan. So a lot of employers have a lot of benefits all wrapped into a cafeteria plan or a Section 125 plan. And there is thankfully a rule, the ERISA rules basically say that if you throw non-ERISA plans into a cafeteria plan with other ERISA plans, you're not going to make those non-ERISA plans subject to the ERISA rules, thankfully. Makes things a little easier. And makes your compliance a little easier. Another thing with bundling, and this is what I really wanted to talk about, is what I call the mega wrap. I think of it as a Gilbert Brown burger. I'm from Milwaukee, and that's what I do. But it's basically, you can take all your ERISA plans and put them in one mega wrap plan. And what that does is you can take your health, your dental, your vision, any ERISA plan that you have, and put them under one giant wrap document. And if you think of it, kind of like wrapping paper or, like a present, you put all your plans in a box and you wrap it with the mega wrap. Then you only have one ERISA plan and you only have one SPD to do. It's a big SPD, but you only have one SPD. You only have one 5500 filing to worry about. And so that it can make things a little easier from the administrative side if you want to.
All right, so going more into the specifics about the summary plan description, the SPD, and who has to be provided with that SPD. So with the summary plan description, there is no small plan exception. Whether your plan covers one individual or 2,000, all plan participants and beneficiaries have to be provided with a summary plan description for all of their ERISA welfare plans, so health plans, retirement plans, pension plan beneficiaries obviously have to get a copy. There's plan sponsors are also required to provide beneficiaries and participants with copies of the SPD when they make the written request. They're automatically entitled to receive that once they become a participant. So you have to make sure that that is something that you're distributing to these participants and beneficiaries. There's also a requirement that they be provided free of charge. So this isn't something that you can charge back to the employee, participant, or beneficiary. There's also situations where these have to be furnished to COBRA qualified beneficiaries. They have to be provided to a parent or guardian under a qualified medical child support order. So that's an order that provides for child support and health benefit coverage for a child under a group health plan. These typically stem from, a divorce or some other type of custody matter. But those, the parent or guardian also has to be furnished a copy of a summary plan description when there's one of those orders in place as well. And then they also have to be provided to a spouse or other dependent if you have a retiree that passes away who remains entitled to benefits. So there's quite a lot of requirements here as far as who has to be required with that SPD.
And then talking about how to actually furnish those SPDs, there are timelines, thankfully, to the IRS, DOL. They give us guidance in terms of how many days we have to furnish these. 90 days to new participants once they first become covered. Generally, you can cover that by giving them a copy of the SPD when they enroll or with the enrollment form, so you don't have to worry about it. New plans, if you start a brand new plan, it has to be distributed within 120 days of when the plan is, born. You have to update your SPDs to all covered participants every 5 years. They say you can do it every 10 years if you don't have any changes. I don't think I've run across one that hasn't had a change in, a 5-year period, be it changing insurance companies, changing anything regarding the plan. I think it's probably the exception rather than the rule that you'll see that. Plus, as I indicated earlier, if you do make changes, you're going to want to update your SPD every year anyways, because you're going to have new enrollees. If you're having new hires, that you're going to have to give them an up-to-date SPD anyways. And distributing them, you have to give them out in a way that they say, quote, is reasonably calculated to ensure actual receipt of the material, end quote. And there are rules regarding employees who can receive them by email and those who cannot. There are rules about how you mail them. It's basically makes it pretty hard to distribute to everybody by email unless they sign an acknowledgement accepting that, and there's a whole bunch of rules with that. But there's a case that really points out why this is important to distribute these correctly and why you don't want to run afoul of the distribution rules. And it's called the Raymond Thomas case. It's pretty straightforward. Judith Thomas worked at Countrywide Financial, and she had benefit plans, including a voluntary life insurance plan that she bought into. And that plan required premium payments by the employees, and Judith, unfortunately, went out on disability and stopped paying her premiums. She was not aware that she could have filed a waiver of premium form that would have kept her insurance in place while she was out on disability, because she did not receive the SPD in a way that was acceptable to the DOL under ERISA. Judith, unfortunately, passed away after her disability stay. And her brother, Raymond Thomas, filed a claim for benefits after she died. And his claim was denied by the life insurance company, clearly because she failed to pay premiums. At that time, Raymond sued the employer and the insurance company, claiming that the SPD was delivered improperly to his sister, and as such, she had no way of knowing that there was a waiver option, and therefore he should be entitled to the insurance proceeds. And the court, just because the SPD was delivered improperly to Judith, agreed with Raymond Thomas and said, yes, you have to pay Raymond Thomas all this insurance money that she was owed, and that was probably some of the least of their problems, because all the attorney's fees involved in this case going up on appeal, easily exceeded, I would say probably $250,000. So that's why it's important to get this stuff right.
Yeah, absolutely. So the next slide here is summary of material modifications. I'm not going to go into this too much. We've kind of glossed over a bit of this, but if there's a change, including establishing new benefits, taking away existing benefits, either narrowing or expanding the circumstances when benefits are paid, or terminating that plan entirely, those can be situations that give rise to the need to issue a SMM. And just a couple of timelines here. They have to be provided in the same manner to the same individuals as an SPD, again, in a way that will result in actual receipt by the participant. So it has to be calculated to actually make it to those participants. And it has to be furnished within 210 days after the end of the plan year. So a really interesting requirement on the time frame there. But there is a shorter time frame. If there's a material reduction in those covered services, then it has to be furnished no later than 60 days. So after that adoption of the reduction. So just a quick overview. We kind of have already touched on SMMs enough. I don't need to continue beating that into your head. So
SBC's summary of benefits and coverage. Switching gears slightly, these are, if you've ever seen them, they all actually look the same. There is a government form out there that you just tweak to change what is in your SBC, but you might see them if you're contemplating choosing between different plans. They show you what your deductible options are, your premium options are, what's covered, what's not covered, and there's a whole bunch of statutory language that's required in terms of definitions. These generally are provided by the insurance company. I find that they'll provide these because they have all the information and they give it to you. If not, there are forms out there that you can just fill in to get these things done. And if you don't get them done, Janelle's going to tell us what happens.
Yes. So if we are not making sure that we're complying with these, the penalties, Andy touched on this a little bit, but we've got a few different entities that are able to take a bite of the apple here. So we've got Health and Human Services. They can fine $1,000 for each willful failure to provide that summary. IRS can impose their own $100 per day per individual affected. And the Department of Labor, they have their own bag of goodies here. So they can impose civil penalties that can include $1,100 a day for each day that an administrator fails or refuses to provide a Form 5500, which we're going to talk about here momentarily. They can fine $110 per day for failing to respond to a participant's request for plan documents. So if a participant requests that they receive that and the employer fails to provide it, that can be up to $110 per day. The Department of Labor also has the authority to assess criminal penalties. If they come in and do an audit and they uncover criminal activity like embezzlement or theft by either the plan sponsor sponsors or other types of fiduciaries, there can be criminal charges handed over to the likes of Andy and other federal prosecutors. So there's a lot of enforcement mechanisms here, and the penalties, as we've kind of mentioned already, can really add up. And, traditionally, the Department of Labor audits were, when they would come in to audit employee benefit plans, they were mostly focused on retirement plans. But because the ACA added some new layers of requirements to what you already have to comply with under ERISA, the Department of Labor has actually started to enforce compliance with the ACA, and then those health plan audits, kind of go hand in hand. So where this didn't get enforced a whole lot before, the Department of Labor audits of ERISA benefit plans are definitely on the rise, and this is coming more to the forefront for a lot of employers and counsel who work with employers. So definitely wanting to make sure to pay attention to those fines because they do add up quickly.
And here is a fun list of documents that you get to provide in addition to the SPD under ERISA. When I draft ERISA or SPDs, I put a bunch of this stuff in there, as Janelle knows, because she's used my beautiful, beautiful template. Some of these, though, are not covered. That would not make sense to be putting into an SPD. So make sure you understand what your requirements are in terms of distributing these notices, either annually or upon enrollment, or both. Or some of these, such as the trust agreement, are only subject to distribution upon written request by a participant.
So moving on to talk about the Form 5500 reporting. This is a form that, unless you are exempted in some way, the plan administrator has to file this report. It has a lot of requirements. There's financial requirements, so you have to include a schedule of assets and liabilities. There has to be information about each insurance contract that's used. Any service provider has to be listed. Pension benefit plans, there's a separate schedule for those. You have to give out some financial transactions, loans, fixed income obligations, actuarial details, accountant reports. There's many required components of the Form 5500. And that's because it's intended to make sure that employee benefit plans are being operated and managed in accordance with the standards. And it also is to show participants, beneficiaries, and unfortunately regulators that you are, as the employer, providing or have given your employees sufficient access and information to protect their rights and benefits. So if we think back to those poor Studebaker employees who were laid off just before Christmas, giving this information, making sure that these assets are protected, this is part of this Form 5500. And it's to report those obligations. Those reporting obligations, like I said, apply to each ERISA plan as employer sponsors. So again, another important form that employers need to be making sure they are completing.
There are penalties for not doing your 5500s. Quite stiff, up to $2,100 or 2,100. I can read. No commas, so it makes it harder. $2,100 a day for every 5,500 that's been incomplete. And there's also a possibility for criminal penalties if it's a willful failure. These penalties keep adding up, and depending on how many plans you have, you get one for each one. There's no statute of limitations on this, which is absolutely crazy. So they could theoretically go back 50 years and fine people $2,100, bucks a day for every 5,500 they didn't file. Good news though is that there is a voluntary correction program where you can go back and you can fix your errors. And if I remember right, the last time I looked at it, I think there is no penalty if you go through the voluntary filing plan, which is a steal.
All right, so there is a small insured plan exemption, unlike with the SPD requirement. So if you are a small plan, meaning having less than 100 covered participants, then it is possible that you do not have to comply with this Form 5500 exemption. You do have to make sure that you're including COBRA qualified beneficiaries and retirees. It doesn't include spouses and dependents, but there is an exemption here as well. And I do want to leave some time here while Andy kind of chats about our ERISA Complete solution. I'm going to get us set up and do just a real quick demo so you guys can kind of check out how, now that we've scared the pants off you, how we can actually help you out.
Yeah, so we do have a solution called the ERISA Complete, and what it basically does is I've created a calendar that has all the requirements of what kind of notices you have to give, when you have to give them, and I think I included on there the penalties just for fun. But if you were to be an ERISA compliant customer, not only do I have the list of the files or the list of the forms that you have to fill out or forms that you have to provide, I also have links to documents, form documents that you can use, like a Form SMM if you wanted to do that, a Form SAR. I know for sure. I have links to language on all the required notices. And if you were an ERISA Complete client, you would get the SPDs drafted by us as well. And so what we have there is we have a questionnaire to do the SPD process. And the SPD process is pretty straightforward in that it's a questionnaire. We ask you some questions. We ask you to send in your plan documents. And then we create an SPD wrap for you. And that SPD wrap is fully compliant. It will stand any ERISA audit that you come up to. And it will be the best SPD you ever saw in your life, because nobody probably has ever read their SPD before.
Very true. So I just logged on, pulled up our compliance center here, and this is, obviously the homepage here. So you can log on, go to the Solution Center, click on Compliance, and if you scroll down here, we have an ERISA box where you can access that dynamic compliance calendar that Andy was talking about. So this is going to go through and show you all of the different requirements that you need to have, comply with, when you need to comply with it, and again, the penalties, to make sure that you are aware of, the penalties that can correspond here. So anybody can access this calendar. I will log in quickly just to show you what it looks like if you are signed up for ERISA Complete. All right, so if we go back to the Solution Center, go back to Compliance, go back to ERISA and the calendar. Now when you're logged in and you click on, for example, Review of Plan Documents, it's going to take you to a page where you can actually submit your documents to an attorney. So if you want to have an attorney look over your health and welfare benefit plans and make sure that they are compliant, you can come here and submit those here. If you are wanting to go through that summary plan description process, you would click on that. This brings you to a page where you can access our checklist, our questionnaire. So this questionnaire, it actually just pulls up into a Word document. Let's open it up here so you can take a look at it. But it pulls up a nice Word document. You go ahead, you fill it out and provide us with any of the information that we're going to need to be able to complete that for you. And let me just move it here. So this goes through the process. You fill all of this out, the name of the contact person, information about your plan. You'll save it, and then when you're ready to submit that, you'll click on Submit to an Attorney, And this will actually take you into our portal where you'll be able to get that. Oh, sorry, it took you to Mark's page here. But if you weren't logged in and you would come here, you would just fill out your login. I can have no typos. You would get logged in. You would submit your request to ask an attorney. And it looks just like an email box. So you would put in your subject, SPD, a quick description, add the file that comes into an attorney like me or Andy. And then we get the lovely task of making sure that you have a compliant summary plan description. So just a quick overview of our website here. Just wanted to make sure to show you how we can help you be compliant on that. And I do see we did have one question about whether we were able to email out the slideshow. And that's definitely something that, we can work with everybody at Grid Group to make sure we get submitted. So if people are interested in getting a copy of the deck, we can make sure that David or somebody gets that out to you. So that is all we have for material here. Did anybody else have any other questions? It is a fascinating topic. I'm sure, you might have a million questions you maybe just don't want to ask here, and we can certainly understand that too. If you have questions, obviously we can always be reached as well. And I'll just put up our contact information here so you can see that.
And I'll just chime in for just a second. Thank you guys for presenting today. I know that it is kind of a dry topic, and thank you all for all of our Grid Group clients that stayed on. I know that we lost a few, probably due to time constraints. We will be sending out the slide deck, but better yet, I hope to get a copy of the recording of today's session to be able to send out to everybody. Additionally, I know that we sent out a flyer in regards to the information for some compliance pieces that the staff and attorneys at MyRetro Counsel talked about. All of our clients have access to the general information, but if you guys were interested in any of the other services that MyRetro Counsel offers, you can reach out to me directly, and we can kind of get you specific pricing for your organization separately if it's something that you want to look into.
Perfect. I'm still not seeing any other questions. So with that, I think we can wrap up here. And we do thank everybody for your time and hanging in here with us on this presentation.
Thank you, everybody.
Have a great day.